Thank you for the floor. Thank you, Central European Academy, for inviting me, and Professor Muszyński for inviting me to the project. The title of my presentation is, as you can see, the political mission of restoring the rule of law in Poland after 2023, theory and practice. The political circles forming the current government in Poland came to power under the slogan of restoring the rule of law. They formulated an accusation that the past years the legislative and executive authorities have deviated in their activities from constitutional standards inherent in a democratic state of law, including, above all, the principles of rule of law and the division of balance of powers. It has been claimed, for example, that the system of monitoring the constitutionality of law in Poland has become dysfunctional. In connection with these accusations, a number of measures were announced to will be adopted to restore the state of compliance with the Polish constitution. The purpose of my speech is to consider to what extent these assumptions of the political mission of restoring rule of law has been realized, to compare the theory with the practice within the executive branch. To this end, I will present the constitutional model for the operation of the Council of Ministers and the government administration. Then I will point to some examples of practical implementation of the postulate of restoring the rule of law and characterize the compliance of these actions with the constitutional standards. Chapter 6 of the Constitution of the Republic of Poland was dedicated to the Council of Ministers. The Council directs the government's administration, coordinates and supervises the work of government administration bodies. The Prime Minister ensures the implementation of the Council of Ministers policy and determines the method of its execution, as well as coordinates and supervises the work of the members of the Council of Ministers. Ministers direct specific departments of government administration. The President of the Republic of Poland, the Council of Ministers, and the Prime Minister, in performance of their constitutional tasks and competences, are guided by the principle of cooperation among the authorities of the Republic of Poland. This principle obliges mutual respect for the scope of constitutional tasks of state bodies, their competences, as well as respect for the dignity of offices, mutual loyalty, acting in good faith. The idea of cooperation is the consequence of the fundamental constitutional principle expressed in Article 1 of the Constitution, that the Republic of Poland is the common good of all citizens. Article 10, paragraph 2 of the Polish Constitution establishes the principle of dualism of the executive power. The President of the Republic of Poland and the Council of Ministers operate as structurally, competently, and functionally distinct bodies of this authority. The President of the Republic of Poland, in the sphere of realizing the functions and tasks assigned to him by law, acts independently of the Council of Ministers on his own account. The principle of President's functional independence has been constitutionally limited in issuance, especially in issuance of official acts. Some of them the President performs independently as so-called prerogatives, while the others require countersigning by Prime Minister. The Constitution imposes a requirement on public administration to act in a diligent manner. Diligence includes, in particular, the assessment of actions in terms of both due diligence in conducting activities and the substantive tasks being carried out, as well as adhering to existing standards, rules, and parameters in a given activity. The essence of Article 7 of the Constitution, as my honorable colleagues mentioned, is the mandate for the public authority bodies, including the Council of Ministers and government administration, to act within the limits set by law, which should include the basis for their action as well as the boundaries of their activities. The legalism of public administration bodies' activities consists, among other things, in issuing decisions in the form prescribed by law, on an appropriate legal basis, and in accordance with the binding material regulated for that body. The violation of state authorities of the obligation to act on the basis and within the limits of law causes such action to lose its legal character. This rule does not provide for any exemptions. A public authority cannot attribute to itself competences that are constitutionally reserved for other bodies. It is therefore obliged to adhere to all regulations defining its powers or duties. Public authorities must therefore be familiar with the provisions of substantive, procedural, and, let's say, constitutional administrative law regulating their competences and adhere to the resulting mandates and prohibitions. Above all, it is about the public authorities not applying the principle that what is not prohibited is permitted, but rather applying the opposite principle, that what is not permitted is prohibited. The addresses of the principle for legality are all state bodies regarding of their classification: legislative, executive, and judicial power. From the constitutional principle of legality, it follows that they cannot take actions without a legal basis or avoid exercising their competences in binding legal norms, impose specific obligation on these bodies. The Constitutional Tribunal expressed the view that the principle of the rule of law is an instrumental principle with respect to the principle of legal certainty and the citizen trust in the state, in the sense that acting on the basis of and within the limits of law is a necessary condition for realization of principles of certainty and trust. The issuance of a decision in accordance with law is guaranteed by appropriate procedures, including the right to appeal decisions and their judicial review. The consequence of the above solution is the durability of the decision, which is presumed to be in accordance with the law. Durability is therefore an element reinforcing the principle of the rule of law. I will now move to identify examples of political actions done by the executive branch that have raised the most doubts among representatives of doctrine of constitutional law from the perspective of the principle of the rule of law. In January 2024, National Prosecutor Dariusz Barski received a document, not a decision, only a document, a letter even, from the Attorney General stating that his reinstallment to active duty in 2022 by the previous Attorney General was done in violation of the current legislation and had no legal effect. This is because a provision of the law that was no longer in effect was applied, according to the Attorney General. A new person was appointed to the position of National Prosecutor, but this decision is contested by the part of the legal community, including even prosecutors, many prosecutors. The Supreme Court and the Constitutional Court had also spoken out against the decision. In a resolution taken in September 2024, the Supreme Court stated that reinstatement of the dismissed prosecution to active service and his appointment as a national prosecutor in 2022 had a binding legal basis and was effective. In response, the new leadership of the National Prosecutor's Office said that the resolution had no legal effect because it was taken by unauthorized persons. In turn, the Constitutional Court ruled in November 2024 that the removal of the national prosecutor from the office was unconstitutional and restricted his access to public Service. Responding to this judgment, the Attorney General stated that the examination of the constitutional complaint of the dismissed prosecutor was inadmissible, as a formal requirement for filing it had not been met. So, the Attorney General questioned the independence and impartiality of judges appointed with participation of National Judicial Council formed under the 2018 law. This reasoning is not based on any formal grounds or any sources of law, but only on the opinion of the part of the doctrine of the constitutional law and politicians. So the opinion of the doctrine is for the Attorney General the source of the base for making such important decision, being opposing the decision of the Supreme Court and the Constitutional Tribunal. Constitutional doubts arise in evaluating certain actions of the Minister of Science as well. An example is the interruption of statutory terms of bodies operating in higher education. For example, the law of National Science Center stipulates that in order to identify candidates for member of the Council of the National Science Center, the minister shall appoint a council member identification team for a period of 4 years. But the minister dismissed the team members appointed by his predecessors and appointed new persons in their place. Meanwhile, like any other public authority, the minister is obliged to act on the basis of law and within the limits of Article 7 of the Polish Constitution. This means that he undertakes every action on the basis of, should undertake every action on the basis of competence he has, the competence in the normative act assigned to him. In this case, the minister is obliged to indicate the provision under which he is competent to perform the action of dismissing the chairman, for example, of the identification team. But he didn't. He assumed the competence without the clear legal basis for that. Third issue. In the effort to introduce changes in the public media, the new Minister of Culture and National Heritage replaced the management and supervisory boards of Polish television, Polish radio, and Polish press agency without legal basis and bypassing the National Media Council. The dismissal of the supervisory boards by the Minister of Culture and National Heritage and the appointment of a new ones in their place, on the other hand, was without legal basis. The statutes of government media clearly state that the supervisory boards are appointed and dismissed by the National Media Council. Again, in January 2024 ruling, the Constitutional Court ruled that certain provisions of both the Broadcasting Act and the Commercial Companies Code are unconstitutional, and the minister's action have no legal effect. The Culture Ministry, in turn, is of the opinion that Constitutional Tribunal judgment was rendered in the wrong composition and has no legal significance whatsoever. These are official statements, for example, made on the press conferences or put on the official websites of the state bodies, ministries. Another element of the government's policy is also controversial. The Government Legislation Center, which is some unit under the supervision of the Prime Minister, has stopped publishing Constitutional Court verdicts in the Journal of Laws of the Republic of Poland, since the same adopted a resolution on the 6th of March 2024 to remove the effects of the constitutional crisis of the 2015-2023. The resolution says that also public authorities are obliged to respect the Constitution, and in particular the principle of legislation under Article 7 of the Constitution, in which of the contested composition of the court, the inclusion of constitutional court rulings in the activities of a public authority would constitute a violation of the principle of legalism by those authorities. It is indeed the reversed rule of law. Acting against the clear provisions of the Constitution that clearly says that the judgments of the tribunal should be published, is presented as the violation of the principle of legalism. In September 2024, the Prime Minister withdrew his counter-signature under President Andrzej Duda's decision on appointing the chairman of Assembly of Judges of the Supreme Court Civil Chamber to select candidates for the chamber's president. Withdraw signature under President decision. Construction from the legal point of view, or the point of view of the legal doctrine, not known to the legal world. The Prime Minister cited the fact that two Supreme Court judges from the Civil Chamber had challenged his counter signature before the administrative court, and that the administrative procedure allows an administrative body to rescind its decision under so-called self-control. Of course, it is, but it is on the level of the statute. The Constitution doesn't mention anything like that. The Prime Minister's decision to withdraw the counter-signature is causing great controversy among lawyers, as the withdrawal of the counter-signature is unprecedented action in the history of Polish politics. Constitutionalists argue that it is not possible to withdraw a counter-signature. A counter-signature is a placing of a signature by the Prime Minister on the President's decision. The counter-signature is followed by effects that cannot be undone by unilateral action of the Prime Minister. Okay, and summing up, the political project of restoring the rule of law resounds with war military rhetoric. Restoring the rule of law is like the action of a sapper. One of the journalists expressed like that, action of the sapper, who sometimes strays from the patch of legalism to save the rule of law in his mind. Polish Prime Minister said, if we want to restore constitutional order and the foundation of liberal democracy, we must act in a term of militant democracy. This means that we will probably more than once make mistakes or take actions that, according to some legal authorities, may not be in accordance with the letter of law, but nothing relieves us of our duty to act. In my opinion, the idea of taking shortcuts, ignoring the letter of law, can provide to be a double-edged weapon. Social processes have their own dynamics. Screwing up the spiral is not without consequences. We don't know whether a particular act is really an exceptional act or whether it will become a systemic practice that blows the last constitutional barriers for the executive power. Thank you for your attention.